According to the UN Global Report on Crime and Justice 1999, the rate of imprisonment in India is very low, that is, 25 prisoners per 1 lakh of population. In comparison to Australia, 981 prisoners, England 125 prisoners, USA 616 prisoners, and Russia 690 prisoners per 1 lakh population. A large chunk of prison population is dominated by first offenders, around 90%. The rate of offenders and recidivists in prison population of Indian jails is 9:1. Despite the relatively lower populations in prison, the problems are numerous. As per records of 2007, the prison population was 3,76,396 as against an official capacity of 2,77,304, representing an occupancy rate of 135.7% distributed across 1,276 establishments throughout the country. The prison population has been steadily increasing during the last decade. The majority of the prison population is male, nearly 96%, and approximately two-thirds are pre-trial detainees under trials. The contemporary prison. The contemporary prison administration in India is a legacy of British rule. It is based on the notion that the best criminal code can be of little use of a community unless there is a good machinery for infliction of punishment. In 1864, the Second Commission of Inquiry into Jail Management and Discipline made similar recommendations as the 1836 Committee. In addition, this commission made some specific suggestions regarding accommodation for prisoners, improvement in diet, clothing, bedding, and medical care. In 1877, a conference of experts met to inquire into prison administration. The conference proposed the enactment of a prison law and a draft bill was prepared. In 1888, the Fourth Jail Commission was appointed. On the basis of its recommendation, a consolidated prison bill was formulated. Provisions regarding the jail offences and punishment were specially examined by a conference of experts on jail management. In 1894, the draft bill became law with the assent of Governor General of India. International obligations and guidelines. The International Covenant and Civil Political Rights, that is ICCPR, remains the core international treaty on the protection of rights of prisoners. India ratified the covenant in 1979 and is bound to incorporate its provisions into domestic law and state practice. The International Covenant on Economic, Social and Cultural Rights, that is ICESR, states that prisoners have a right to the highest attainable standard of physical and mental health. Apart from civil and political rights, the so-called second generation economic and social human rights as set down in the ICESR also apply to the prisoners. The earlier United Nations Standard Minimum Rules for the Treatment of Prisoners 1955 consists of 5 parts and 95 rules. Part 1 provides rules for general application. It declares that there shall be no discrimination on grounds of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. At the same time, there is a strong need for representing the religious beliefs and moral precepts of group to which a prisoner belongs. The standard rules give due consideration to separation of different categories of prisoners. It indicates that men and women be detained in separate institutions. The under trial prisoners are to kept separate from convicted prisoners. Further, it advocates complete separation between the prisoners detained under civil law and criminal offences. The UN Standard Minimum Rule also made it mandatory to provide separate residence for young and child prisoners from adult prisoners. Subsequent UN directives have been the basic principles for treatment of prisoners, United Nations 1990, and the body of principles for the protection of all persons under any form of detention or imprisonment, United Nations 1988. On the issue of prison offences and punishments, the standard minimum rules are very clear. The rules state that no prisoner shall be punished unless he or she has been informed of the offences alleged against him or her and given a proper opportunity of presenting his or her defense. It recommends that corporal punishment by placing in a dark cell and all cruel, inhuman, or degrading punishment shall be completely prohibited as a mode of punishment and a disciplinary action in the jails. Prisons in India. The management and administration of prisons in India comes under the domain of state governments and is governed by Prisons Act 1894 and the prison manuals of respective state governments. Thus, states have primary role, responsibility, and authority to change the current prison laws, rules, and regulations. Day-to-day administration of prisoners rests on principles incorporated in the Prisons Act of 1894, the Prisoners Act of 1900, and the Transfer of Prisoners Act of 1950. An Inspector General of Prisons administers prisons affairs in each state and territory. The central government provides assistance to states to improve security in prisons, for the repair and renovation of old prisons, medical facilities, development of borstal schools, facilities to women offenders, vocational training, modernization of prison industries, training to prison personnel, and for the creation of high security enclosures. The Supreme Court of India, in its judgments on various aspects of prison administration, has laid down three broad principles regarding imprisonment and custody. Firstly, a person in a prison does not become a non-person. Secondly, a person in a prison is entitled to all human rights within the limitations of imprisonment. Lastly, there is no justification for aggravation, the suffering already inherent in the process of incarceration. Types of prisons. Prison establishment in India comprises of 8 categories of jails. The most common and standard jail institutions are central jails, district jails, and sub-jails. The other types of jail establishments are women jails, borstal school, open jails, and special jails. Type number: central jails 123, district jails 333, sub-jails 809, women jails 19, open jails 44, borstal schools 121, specific jails 30, other jails 3, total 1382. Prisons Act 1894. It is the Prisons Act 1894 on the basis of which the present jail management and administration operates in India. There are hardly any substantial changes in the Act since it has been formulated. However, the prison problems in India continue even after this. In the report of the Indian Jail Committee 1919-1920, for the first time in the history of prisons, reformation and rehabilitation of offenders were identified as the objectives of the prison administrator. Several committees and commissions appointed by both central and state governments after independence have emphasized humanization of the conditions in the prison. The need for completely overhauling and consolidating the laws relating to prison has been constantly highlighted. The Government of India Act 1935 resulted in the transfer of subject of jails from centralist to control of provincial governments and hence further reduced the possibility of uniform implementation of a prison policy at the national level. State governments thus have their own rules for the day-to-day administration of prisons, upkeep and maintenance of prisoners, and prescribing procedures. In 1951, the Government of India invited the United Nations expert Dr. Reckless to undertake a study on prison administration and to suggest policy reform. His report, titled Jail Administration in India, made a plea for transforming jails into reformation centers. He also recommended the revision of outdated jail manuals. Accordingly, the Government of India appointed the All India Jail Manual Committee in 1957 to prepare a model prison manual. The committee submitted its report in 1960. The report made forceful pleas for formulating a uniform policy and latest methods relating to jail administration, probation, aftercare, juvenile and remand homes, certified and reformatory school, bostel and protective homes, suppression of immoral traffic, etc. The report also suggested amendments in the Prison Act 1894 to provide a legal base for correctional work. The Model Prison Manual. The committee prepared the Model Prison Manual (NPM) and represented it to the Government of India in 1960 for implementation. The NPM 1960 is the guiding principle on the basis of which the present Indian prison management is governed. On the lines of Model Prison Manual, the Ministry of Home Affairs, Government of India in 1972 appointed a working group on prisons. It brought out in its report the need for a national policy on prisons. It also made an important recommendation with regard to classification and treatment of offenders and laid down principles. Major problems on prisons relevant to India. Despite the relatively low number of prisons in prison as compared to many other countries in the world, there are some very common problems across prisons in India, and the situation is likely to be same or worse in many developing countries. Overcrowding, prolonged detention of under trial prisoners, unsatisfactory living conditions, lack of treatment programs, and allegations of indifferent and even inhuman approach of prison staff have repeatedly attracted the attention of the critics over the years. Overcrowding. Congestions in jails, particularly among under trials, has been source of concern. If prison overcrowding has to be brought down, the under trial population has to be reduced drastically. This, of course, cannot happen without the courts and the police working in tandem. The three wings of the criminal justice system would have to act in harmony. Speedy trials are frustrated by heavy court workload, police inability to produce witnesses promptly, and a recalcitrant defense lawyer who is bent upon seeking adjournments even if such tactics harm his or her client. Fast-track courts have helped to an extent but have not made a measurable differences to problem of pending cases. Increasing the number of courts cannot bring about a desired difference as long as the current adjournment culture continues. Corruption and extortion. Extortion by prison staff and its less aggressive corollary, guard corruption, is common in prisons around the world. Given the substantial power that guards exercised over inmates, these problems are predictable, but the low salaries that guards are generally paid severely aggravate them. In exchange for contraband or special treatments, inmates supplement guards' salaries with bribes. Unsatisfactory living conditions. Overcrowding itself leads to unsatisfactory living conditions. Although several jail reforms outlined earlier have focused on issues like diet, clothing, and cleanliness, unsatisfactory living conditions continue in many prisons around the country. To improve prison conditions does not mean that prison life should be made soft. It means that it should be made human and sensible. Staff shortage and poor training prisons in India have a sanctioned strength of 49,030 of prison staff at various ranks, of which the present staff strength is around 40,000. The ratio between prison staff and the prison population is approximately 1:7. It means only one prison officer is available for 7 prisoners, while in UK, 2 prison officers are available for every 3 prisoners. Inequalities and distinctions. According to the report of Human Rights Watch, a rigid class system exists in prisons in countries like India and Pakistan. Under this system, special privileges are accorded to minority of prisoners who come from the upper and middle class, irrespective of crimes they have committed or the way they comport themselves in prisons. Inadequate prison programs. Despite the problems of overcrowding, manpower shortage, and other administrative difficulties, innovative initiatives have been undertaken in some prisons. For example, the Art of Living has been carrying out a SMART program in Tihar Jail. This includes 2 courses per month and follow-up sessions every weekend. Two courses are annually conducted for prison staff, but these are more by way of exceptions and experiments. Many prisons have vocational and training activities, but these are often outdated. Hardly any of the prisons have well planned prison programs providing structured daily activities, vocational training, pre discharge guidance, and post prison monitoring. Poor spending on healthcare and welfare in India, an average of US dollar 333, that is 10,474 rupees per inmate per year was spent by prison authorities during the year 2005, distributed under the heads of food, clothing, medical expenses, vocational or educational training, welfare activities, and others, according to National Crime Records Bureau 2005. This is in contrast to US where the average annual operating cost per state inmate is 2001 was $22,650. The latter presumably also includes salaries of prison staff. Lack of legal aid. In India, legal aid to those who cannot afford to retain counsel is only available at the time of trial, not when the detainee is brought to the remand court. Since the majority of prisoners, those in lockup as well as those in prisons, have not been tried, absence of legal aid until the point of trial reduces greatly the value of country's system of legal representation to the poor. Lawyers are not available at the point when many of them mostly need such assistance. Researchers point out that 70% of the prison population is illiterate and lacks an understanding of prisoners' rights. Thus, the poor in prison do not always get the provisions in law, though the state is obliged to provide legal aid. Abuse of prisoners. Physical abuse of prisoners by guards is another chronic problem. Some countries continue to permit corporal punishment and the routine use of leg irons, fetters, shackles, and chains. In many prison systems, unwarranted beating are an integral part of prison life. Women prisoners are particularly vulnerable to custodial sexual harassment. Consequence of prison structure and function. Physical and psychological torture resulting from overcrowding, lack of space for segregation of sick, stinking toilets for want of proper supply of water, lack of proper bedding, restrictions on movement resulting from shortage of staff, parading of women through men's wards for lack of proper separation, non-production of under-trial prisoners in courts, inadequate medical facilities, neglect in the grant of parole, rejection of premature release on flimsy grounds, and several such afflictions result not from any malfeasance of the prison staff but from collective neglect of the whole system. Human Rights Watch 2001. In many places, non-governmental organizations provide rehabilitation programs and few provide aftercare. Most prisoners are not prepared for release. No steps are taken to minimize their chance of committing re-offenses. Programs to develop a set of values, the ethos of honest labor, and to build pro-social ties with the community are essential, however, they are not well implemented. Health problem in prisons. The overcrowding, poor sanitary facilities, lack of physical and mental activities, lack of decent health care all increase the likelihood of health problems in prisons. Though there is not much information available or published on health problems in prisons, an exception is a small study in Central Jail at Hindalga in the Belgaum district of Karnataka. The study showed that 850 prisoners were evaluated and followed up for a period of 1 year, and the results were indeed shocking. 54.82% prisoners were infected by anemia, which was the commonest morbidity, followed by respiratory tract infection, which has 21.75%, and diarrhea 13% for acute morbidity. Pulmonary TB and HIV contributed 2% and 1.5% respectively. Other morbidity included diabetes 3.6%, senile cataract 7%, pyoderma 12%, etc. Modernization of prisons. The scheme for modernization of prisons was launched in 2002-2003 with the objective of improving the conditions of prisons, prisoners, and prison personnel. The components include construction of new jails, repair and renovation of existing jails, construction of additional barracks, improvement in sanitation and water supply, and construction of staff quarters for prison personnel. Activities under the scheme have been construction of 168 new jails, renovation, repair, and construction of 1,713 new barracks, construction of 8,965 staff quarters, as well as improvement of water and sanitation in jails. A second phase has been envisaged in 2009 with a financial outlay of Rs 3,500 crores. However, questions have been raised whether modernization can bring about change without integrity of purpose. Can isolation of any institution from public support and scrutiny make it transparent and attentive to its objectives? Any government that claims attempting to integrate the felon into society first of all should declare prisons is as much as a public institution as that of a university or hospital. Remove its isolation and integrate it functionally and physically into society. Make it police, judiciary, medical, and educational departments conscious of their accountability for pathetic prison conditions. Otherwise, things are not going to change just with allocation of money and launching of schemes. Conclusion. The prison has always been a matter of serious concern. The prison should offer conditions that are compatible with human dignity and conducive to social mainstreaming, and that a person in a custody in a civilized society should be treated like any other human being outside the prison. Prison population have remained at the margins of welfare and development and have seldom been viewed as a need of or deserving of social services. Hence, there is need to focus on prisoners' rights, need for transparency and accountability, monitoring of prison conditions, modernization of prison administration, and sensitization and expansion of prison staff. With the development of criminology as a subject of inquiry, a gradual shift has taken place, whereby the individual alone is no more held responsible for his or her norm or law-breaking behavior. This shift in perspective had led to the development of an understanding of crime causation that includes psychological, social, economic, and political factors as being responsible for deviant behavior in human beings. The shift has included a gradual policy shift away from capital punishment, torture, and debilitating forms of punishment, imprisonment as and not for punishment, more human custodial conditions, protections of legal and human rights, and finally, a focus on retraining, rehabilitation, and social inclusion.